Thank you, everyone that is on this platform for this masterclass module 4. By way of introduction, the co-moderator, he has already introduced me. My name is Ihejirika Kelechi Esquire, a legal practitioner. I'm here to lead us or teach us what the legal compliances and the essential in real estate processes are, what they mean, and why they are very, very important in real estate transactions. Yeah, most of us, when they ask us, who are you, what do you do? They will say, I'm a realtor. I'm a realtor. But most of us don't know what real estate is all about. Most of us don't know what real estate is all about. But we attribute ourselves to be a realtor, and real estate managers, and all the rest of them. I'll quickly go to our topic of today, which is legal compliance, essential in real estate processes. Legal compliance, essential in real estate processes. Yes, today in our society, we can see that real estate, especially let's use Lagos as a case study. We can see that many real estate companies have folded. Some have, in fact, some have left Lagos because of one problem or the other, because of one mistake or the other. When you are into real estate, you must comply legally to every processes. Failure to do that might land you into big problem that you cannot come out of so easily. So legal compliances is the tool which every realtor must adopt in the transaction of real estate. Why do we talk of legal compliances? One of the reasons, or the reasons are ensuring security of title. When you comply to the processes, you are ensuring that the title you are acquiring is highly secured. Because there's a lot of processes we are going to go down as in the course of our studies. We are going to know all these things. Ensuring security of title, knowing the regulatory integrity and investment protection. That is the reason for compliances in real estate processes. The regulatory integrity of what you are going into. The investment protection. If you don't comply adequately or properly with all the processes, your investment might not be protected. You might, in the course of the transaction, lose your property or your investment. So that is why the compliances is very, very essential. It's very, very important. Now, why do we comply? Why do we comply in real estate processes? First of all, non-compliance can land you into serious fatality, such as void transactions. Secondly, it will also attract criminal liability. So it's good that before we involve or we indulge in any real estate transaction, we must do our due diligence. We must comply with the legal essentials before we do or involve in any real estate transaction. Another one is loss of investment. Assuming you are a buyer, you didn't do your due diligence, you didn't consult your lawyer or your surveyor or other relevant persons, it might result to a protracted litigation, which is another factor. You know, our court system these days, a case might stay as long as possible, 10 years, 5 years, as the case may be. You can imagine you just paid for this building to move in with your family by December. At the end of the day, you cannot move into that building as a result of what? A voidable or a void transaction. Now, in the course of this study, it's divided into 5 parts. We are going to go down to it as we proceed. The first part is the regulatory framework governing real estate in Nigeria. There are several laws governing real estate in Nigeria. First is the Constitution, which is the grand norm of all the laws in Nigeria. Before you buy any land, or before you involve in any transaction, whether that transaction is legal or illegal. So the Constitution of Federal Republic of Nigeria is one of the regulatory laws that guides real estate transaction, because we have government acquired lands, we have areas of public interest, so you cannot trade on them. It's illegal ab initio to trade on such lands. A government acquired land is already illegal. You cannot trade on it. So first in this category is the Constitution, which is the grand norm of every law we have in Nigeria. Then secondly is the Land Use Act. The Land Use Act is the most critical statute in Nigeria real estate practice. It gives us all provisions, what we need to know about acquisition of land, what it means, how to go about it, and all the rest of them. As we all know, Section 1 of the Land Use Act vested all the power in the government of each state. All the land is under the government of each state. It's only your governor that have the power over all the lands. That is why we have what we call governor's consent. It's only when he consents, that is when you know that you are a legal owner of that particular land. Then Section 5 also puts the same power on the government or the governor to be the only person that can grant statutory rights. That is statutory right of occupancy, whether the CFO or the governor's consent. That is what Section 5 is saying. It's the governor that have this right. So in anything we do, we must make sure we get our governor's consent or a CFO. Then Section 26 also mentioned that any transaction without governor consent is null and void. And the governor also have power to revoke any land if there's an overriding interest on that particular land. If there's overriding interest on any particular land, maybe that place is meant to be used as a marketplace, as a school, as a playground for the children, for road, for churches, you cannot acquire such lands. So another law governing land real estate transaction is property and conveyancing law. So this property and conveyancing law is the way in which property is transferred from one person to another. When you want to create a legal mortgage, it's the property and conveyancing law that you use to actualize that. Another one is land instrument registration law. Yes, every land acquired must be registered within a particular time. Yes, the date of execution does not count from the day as the day of ownership. Your ownership begins from the date of that registration legally, not that when you buy a land you have perfected your deed, you have signed your deed or what, you are not the owner. No, but I'm talking legally. is when you register that instrument, that land. That is when it starts counting as. Well, that's when the government have taken judicial notice of you, when they have taken notice of you as the rightful owner in case of anything. Do you know the benefits of registration of lands? When there is any problem, if government want to acquire that land back, you are entitled to compensation because you are recognized by government. They are the people that have given you that title. You have your CFO, you have your governor's consent, you are entitled to compensation. But when your property is not duly registered, they don't recognize you, they don't know you, so they have nothing to compensate you with. Another one is urban and regional planning laws. Yes, we can see that most people lost their houses in Lagos State because of this particular law. Many people don't conduct proper search when they want to buy land or buildings. Before you acquire any land, go to the urban and regional planning office to know what is on that land, what that area is meant for. Some people build on top of canals, some build on pipelines, and when government is ready to develop that area with the master plan, you see those houses being demolished. The government is not wicked. They are not wicked. They are executing the proper plan of that area. They are not wicked. Some people will go and give money, just divert it, do this for us. They will do it for you. But at the end of the day, when they are ready to take over that particular area for development, your property will be demolished. Another one is money laundering act. Yes, money laundering act. I know this one will be difficult for most of us to comply with. Yes, because it is our duty to verify or to know the source of income of our potential buyer. But it's difficult for most of us to do because everybody is trying to get a buyer. And you see a buyer, you want to go and verify his source of income. But that is what the law says. You must be held liable if that money is not coming from the right source. If that money is for money laundering or any other illegal transaction and is paid into your account, you will answer for it. So that is why the law says that we owe them that duty to verify the source of our potential clients, know whether that money is an illegal money meant for drugs, money laundering, and all the rest of them. You do your KYC. Another one, if it's a company, the Company and Allies Matter Act, that is the CAMA, is needed to govern the company decision. Before a company will buy a particular land, there must be, or acquire a property, there must be a board resolution. The company must have their meeting, accept and agree, and have a resolution to acquire a property. One person cannot just stand up one day and go and acquire a property on behalf of the company. So it might be voidable if challenged in court by other board members. So that is where Company and Allied Matters Act comes in. There must be a resolution of the board before a company acquires a property. So that is all for the part one. So part two, the core legal compliances. The core legal compliance stage in real estate transaction. So what are the stages? Firstly, pre-acquisition due diligence. How do you go about that? What is pre-acquisition due diligence? First of all, there's what we call deduction of title. The seller must deduce his title for search. You go for a search in different places. One, land, Ministry of Land, Physical Planning Office, Surveyor General's office, and also physical inspection on the land. And also, if you are buying from a family, visitation of the family and neighbors of that family. You must confirm the ownership of that property from the family. You also go extra mile knowing their neighbors, asking questions. Then physical inspection, go to the land, know how that land is. There are some observations you will make. You also go to court records to check whether there's any litigation within that jurisdiction. There's a court. Another one is probate search. Know whether there are people that are struggling over that land as a result of inheritance, whether the families are fighting over inheritance. If you go to probate, all these things, the record, because they will process their letter of administration, know who and who are in that letter of administration, who is processing it, whether it was generally accepted by the people, by the brothers, the sisters, the family. Another one is contractual compliance. What do you mean by contractual compliance? Before you part with your money, if you are paying in instrumental, you must have a contract of sale for you to protect yourself. Then there must be a clear description of the property. Make sure that any property you are buying, there must be a clear description of the property. If the property is not well described, you might buy a wrong property. Second, another one is make selling to you have the capacity to sell. What do I mean by capacity? Let it be that he or she is the rightful owner of that property. If he does not possess the proper documents or the legal right to transfer that title from you, he does not have the capacity. Don't buy. Make sure he is the rightful owner of that particular. You are buying nothing. So at any time we want to buy any property, we must make sure that the person selling to us is the rightful owner, the person that has the capacity to sell. If not, we'll end up in a bigger trouble. Consideration. What do you mean by consideration? When you want to buy a property, make sure that what you have can acquire that particular property. Don't put yourself in a tight corner. If you have 20 million to buy a property, go for a property of 20 million. But if you have 20 million and you want to buy a property of 40 million, be sure of your income within the period you want to buy that particular land or house. We have different documents for different transactions. And like so many people misplace deed of assignment with contract of sale. And they don't know the duty of both documents and also sales agreement. Now, when you go to purchase a land and you want to pay instrumentally, that is where you have what is called contract of sale. You pay instrumentally. It is listed, the ones you have paid, the ones you want to pay, how you want to pay them. You have a contract of sale. That is the document for that. When you are paying outright, you have what is called sales agreement or deed of purchase. Then, if you are buying from the family or you want to perfect your title for a governor consent or a C of O, you have what we call deed of assignment. Deed of assignment emanates from the people that has the original certificate of occupancy, that is C of O, or the original owners of the land. They are the only people that can give you a deed of assignment. Only two people have the capacity of giving deed of assignment. One, the original owners of the land, that's the Omonile. Two, person possessing a certificate of occupancy. These are the two people that can give you deed of assignment. So deed of assignment must emanate from the original owners of the land and person possessing a certificate of occupancy, C of O. Somebody that has a C of O can give a deed to another person. We are now at perfection of title. Perfection of title. What do you mean by perfection of title? Perfection of title means those things we do in order to give our document a legal binding, in order to make our document recognized by the government. The first one is you must go for the stamp duty. Before you register any instrument, there must be a stamp duty. You pay for stamp duty, they stamp it, then you go for registration and governor's consent, and also C of O as the case may be. These are the stages of perfection of title, which you must do in order to give your document or your property a legal face. If you don't do this, there is no way you can lay claim on that particular land if there is an adverse claim from any particular place. It will be difficult for you to prove your ownership. Then coming to development compliances. Yeah, most people just buy a land, they start building on it without going through the due process of getting approval, building approval, or doing their environmental assessment, or getting their planning permit. It is very, very wrong. That is why most people, when they cry that they demolish their house, I don't pity them, because you know. If you don't know, you consult people that know. You consult your surveyor, consult your lawyer for a proper search or a proper documentation. Another one is tax and physical compliance. Most of us in Nigeria here, we don't pay tax. We don't even like hearing about tax, but it's very, very important. Then we also go to the critical risk areas in real estate practice. Critical risk areas in real estate practice. One, family land, sale of family land. Family land is one of the most troublesome lands to transact on if you meet the wrong family. Yes, some family go as far as selling one particular land to 5 or 10 different persons if you are not careful. Then we have government acquisition. As we earlier said, all the lands are vested in government. Government has the power to revoke, to acquire any land if they have overriding interest on a particular area. And government has so many ways of releasing land to individuals and communities and organizations. One of them is gazette. Government can release a land for a community or individual or any other person through gazette. Once that particular area is gazetted, it means that government have released that land. So it's free from encumbrance, it's free from government interference. So you can gladly buy the land without any fear from anybody. Gazette is one of the ways. Another one is a cession. Government can excise a particular area pending gazette or global C of O or the rest of them. So any land that is excised is free from government acquisition if it is duly excised. Okay, so
Yes.
another one is regularization. Okay, when government have allocated a particular land to a particular people, they might go for the regularization of that land. You understand? Maybe the land is for agricultural purpose and you are now changing it for a commercial purpose. You go for regularization in order to make sure that the land is suitable for commercial purpose, what you want to use it for. So all these compliances must be adhered to in order for you to get a good title on your land. Now, if we don't adhere to all these compliances, what do we risk? Revocation and losing of the land. So it's very, very important that we adhere strictly to the compliances. It's very, very important. Don't overlook, don't neglect, don't rely on anybody. Don't rely on hearsay. I hear say that place they free. The owner said that the place is free. Don't rely on the words of the owner. Do your own search so that you can speak for yourself. Okay, the part 5 is best practice compliance framework. As a realtor, there are some things you need to do to protect yourself before you sell any property to anybody. First of all, when you want to market a property, demand for the document for verification. Secondly, you check for the capacity. Know that the person that is asking you to market this property, whether he or she is the owner of that property. Another one is encumbrance checking. Check whether that area is encumbered. What I mean by encumbrance is whether there is government eye on that land, whether that place has been mapped out for a particular project, a particular government project. That is what I mean by encumbrance. So verify all these things before you put up a particular product out for marketing. Another one is approval, regulatory approval. If it's a building that you are marketing, know whether the builder or the developer has all the regulatory approvals, building permit, environmental assessment, all the rest of them, survey plan, registered survey, registered deed, governor's consent. So all these things, you have to verify them, not hearsay. I'm hammering it, not hearsay. Hearsay will lead you into trouble. Make sure that the document you are parading is a good document. Don't parade a fake document. It will also land you into trouble. Now, how do you preserve your documents as as a realtor? Any document that is given to you, make sure you make copies of it. Because at the end of the day, if there's any issue, you are supposed to present, look at the document he gave me. Oh, this is what I presented to so and so person. Make sure you present all those approval, you preserve all those approvals that was given to you, you document them. If you are marketing for anybody, collect all those things, document them properly, put them in a file, so that in the day of reckoning, you bring out that file. Oga, you gave me this document. You said it's this, you said it's this, you said it's this. You use it to protect yourself. But when you don't have proper records of those documents, you might end up getting into trouble. Coming to the consequences of non-compliance in all these things we have been saying, coming to the consequence, it has grave consequences. One is nullification of transaction. If you go and pay to a wrong person, Mr. A is the rightful owner of this property. You now go and pay to Mr. B. You stand the chances of losing that particular property because you did not buy from the rightful owner of that particular property. You did not buy from the rightful owner of that particular property. So that is why we must make sure that what we are presenting the right property from the right person before we put it in the market. Secondly, demolition of property. If you don't get the right approval, building approval, environmental assessment, survey plan, and all the rest of them, if your house does not have it and you went ahead and built on a government reserved area, government acquired area, a place that is encumbered, your house will face demolition. Another one is criminal prosecution. When all these things are happening, who will they call first? The rector, the person that introduced them to their property. So you need to protect yourself in all these things. Make sure that you comply before you present any property for anybody. And it must also result to loss of investment. The person you introduce to buy the property might lose his money, because of the wrong transaction. So it will not be good of you. It will not give you a good reputation and integrity that you introduce somebody, he bought a property through you, and he or she lost his investment or his money. In conclusion, legal compliance in real estate is not merely procedural. It is protective, strategic, wealth preserving. In a jurisdiction where land is governed, controlled, documentation determines ownership, registration determines priority, compliance determines validity. The lawyer is not just a drafter, he is the custodian of investment security. Where there is no valid root of title, superstructure collapse. You must make sure that any property you are buying must have root of title. Trace it to the root. Trace it from the origin so that you will be in good standing whenever the time comes. If there is any issue, you must stand firm to defend what you are selling. Make sure that you do your due diligence, proper documentation, and proper search. Thank you very much for listening and waiting till this moment. This is where I draw the curtain for today.